Hello, good evening, ma'am.
Good evening. Hi.
Hello,
Am
ma'am.
I audible?
Yes, ma'am, you're audible. Yes, ma'am.
Okay.
Yes, ma'am. I'm Gauri Gulati, ma'am, and I will be coordinating the event today.
Yes.
So, ma'am, shall we start or should we wait for 5 more minutes? Some participants are still joining in.
We can wait for 5 minutes. By then, am I allowed to share the slide? I
Yes,
mean,
ma'am, I have made you the
yeah.
co-host. Yes, ma'am.
Okay. Just see whether you're able to see the slide or not. I'm sharing it.
Sure, ma'am.
Can you see the slide?
Yes, ma'am.
Okay. I'll just check. Okay.
Yes, ma'am, it's visible.
Can you see the first slide?
Yes, ma'am.
Yeah.
इकडनं लिंक पूर्ण झालं
Participants are requested to kindly mute themselves.
We shall wait for 2-3 minutes.
Yes, ma'am.
Yeah,
Then
yeah.
we'll start. Sure, ma'am.
Okay.
Okay, ma'am.
म्हणजे आता आपला आवाज चालू
Yes, ma'am. Shall we start?
Yes.
Yes, ma'am. So good evening, everyone. Welcome to the day 3 of the National Level Workshop, come 1 week faculty development program, organized by Guru Angad Dev Teaching Learning Center, a scheme under Pandit Madan Mohan Malviya National Mission on Teachers and Training, Ministry of Education, Government of India, powered by Dwight Pinnell Group, a unit of Arjun Das Gulati Memorial Society. So today on day 3, we have with us Dr. Anushka Nayak, Professor, LNCT University, Bhopal. She is our resource person for today, and the topic is intellectual property rights. Welcome, ma'am. Ma'am, you may proceed with the session now. Over to you.
Thank you, madam.
Thank you.
First of all, let this be an interactive session, right? And firstly, I would like to know from the participants that what do they know about intellectual property rights, firstly, and secondly, what kind of participants are there? I mean, are they all law students or they are from different streams?
Ma'am, they are from different streams, and some are faculties also. They are faculties of different universities and colleges. So they are assistant professors, basically. Yes.
So are there law aspirants as well? Law
Uh,
teachers, law faculty
yes,
teaching
ma'am.
law as well?
Yes, ma'am. Yes, ma'am.
Okay. Okay. So shall I start?
Sure, ma'am.
Yeah. Very good afternoon to everybody, the organizers and the participants. Thank you for giving me this opportunity to deliver the lecture on intellectual property rights. And let's start with it. Firstly, my question is to the participants. What do you understand by intellectual property rights? Anyone from the participant would like to answer? Yes. Anyone?
Ma'am, intellectual property rights are basically those rights which are got by the individuals who do like some work or who come up with some work, invention or something for which they get exclusive rights, which is basically out of their own intellectual and skills they have developed. So those are, and there are various kinds of intellectual rights as mentioned in your PPT.
Yeah. Yes, yes. Very correctly said, ma'am. Intellectual property rights are those rights. First of all, what do you mean by intellect? So intellect, something which is created by our own intellect, by our own mind. So creation of a mind. So this is the reason why it is called intellectual property rights. What kind of rights? Rights which are exclusive in nature, and by exclusive, I mean to say, or I mean to claim here that these rights are those rights which actually excludes the other person from using it. So these are exclusive rights which will be used only and only by the person who has owned it or who is the registered, for example, patentee of it, or a company who is owning the trademark of that particular logo or a particular name, for example, Reliance. So there are many, there can be many examples, and I'll be quoting many examples as I proceed further. So intellectual property rights, what are the kinds? There are various kinds, as we all know. So let's study it one by one. So trademarks, patents, it includes copyright, geographical indications, designs, layout and integrated circuits, undisclosed information, and the trade secrets. Moving further, let me start with, I'll take it one by one. So firstly, I'll be taking trademark. So around, it has been estimated by WIPO, that is the World Intellectual Property Organization. It is an international organization which actually looks into the intellectual property rights, and there are guidelines which are mentioned in the convention. Moving ahead, so it is estimated by WIPO that an average person sees or hears more than 1,500 trademarks each day. So how? See, so from morning till night, These are some of the examples. These are some of the logos, trademarks जो कहीं ना कहीं हम मॉर्निंग में उठते से ही रात को सोते समय तक यूज करते हैं. These are some of the pictures are there. Some of the logos and trademarks are given here. And the time estimates कि पूरे हम दिन में कितने logos या कितने intellectual property हम लोग use कर लेते हैं. We see it or we use it. Moving ahead. So the law which is relating to trademark is the Trademark Act 1999. It came up for the basic purpose was to get the goods and services registered और उनको एक exclusive right दे देना, protection दे देना, so that अगर कोई fraud हो रहा है, right, या कोई default है कहीं ना कहीं, या कोई mark या trademark कोई किसी और का use कर लेता है, कॉपी कर लेता है धोखाधड़ी से, या कोई फ्रॉड का केस होता है, then in that case the user or the owner of that particular trademark can actually claim protection under this particular act. So it is applicable for goods as well as services. And the act came into force on 2003 में exclusively ये enforce किया गया. Moving ahead, what this particular act includes. So these are the definitions जो कहीं ना कहीं बहुत important है. What is trademark and what is mark? So there is a definition of certification trademark, which is given under section 2. So what is a trademark? It is a mark which distinguishes the goods or services as certified in the respect of origin, matter, mode of manufacture, performance of services, quality, accuracy, or other character features of that particular mark. So this is the specific definition which actually gives you the elaboration of what will be included in the trademark, which will be certified under this particular act. Then collective mark. It is a trademark which distinguishes the goods or services of members of an association of persons. Now this is an important definition which is of deceptively similar. One of the important component to prove trademark is that that particular trademark should be deceptively similar with the registered one. So what do you mean by deceptively similar? आप इस word से देख सकते हैं कि deceptively similar, deceptively का मतलब है deception, which deceives, right? So what is it? A mark shall be deemed to be deceptively similar to another mark if it so nearly resembles that other mark to be likely to deceive or cause confusion. So there are two or three terms which is very important over here. Firstly, similarity, resemblance, right? Second, deceive, and third one is confusion. ऐसा कोई मार्क जो बायर के दिमाग में कहीं ना कहीं कंफ्यूजन पैदा कर दे. फॉर एग्जाम्पल हमने बहुत सारे कॉपीज देखे हैं, जैसे एडिडास हो गया, नाइकी हो गया, तो उनके जो लोगोज हैं उनके साथ छेड़खानी की जाती है, कलर चेंज कर देना, या फिर पैटर्न, जैसे नाइकी राइट का मार्क यूज करता है, या फिर एडिडास की स्पेलिंग चेंज कर देना. एक बहुत कॉमन एग्जाम्पल मैं दूंगी पार्ले जी का. बीच में पार्ले जी का कलर कॉम्बिनेशन डिफरेंट करके और उसमें जो डॉल है उसका थोड़ा बहुत चेंजेस करके कहीं ना कहीं मार्केट में सिमिलर काइंड ऑफ बिस्किट्स विद अवेलेबल, तो वो कहीं ना कहीं डिसेप्टिवली सिमिलर की कैटेगरी में आ जाता है. इसका बेसिक पर्पस क्या है? टू क्रिएट ए काइंड ऑफ कंफ्यूजन इन द माइंड्स ऑफ बायर, दैट्स इट. और अगर ये कंफ्यूजन पैदा कर रहा है कहीं ना कहीं बायर के दिमाग में, तो वो डिसेप्टिवली सिमिलर की कैटेगरी में आ सकता है एंड प्रोटेक्शन कैन बी क्लेम्ड बाय द ओनर. नेक्स्ट, व्हाट इज द टेस्ट ऑफ डिसेप्टिव सिमिलैरिटी? जैसा कि मैंने आपको अभी बताया, टेस्ट सिर्फ इतना ही है कि कहीं ना कहीं वो एक कंफ्यूजन क्रिएट कर रहा है बायर के दिमाग में. सो लेट मी रीड इट फॉर यू. What exactly is the test? Test is whether the defendant's use of that mark is likely to cause confusion, right? whether an appreciable number of reasonably prudent customers are likely to get confused or deceived as to the source, affiliation, or scholarship of the parties relating to goods and services. So in this particular condition, जो term important है, that is likeliness of confusion, right? And if likeliness of confusion अगर prove की जाए in the court of law, then intention भी आप prove कर सकते हो उस particular party का, जो कहे defendant का या party का, जो कहीं ना कहीं डिसेप्शन के थ्रू या कंफ्यूजन क्रिएट करके एक नकली प्रोडक्ट या फेक प्रोडक्ट बाजार में बेच रही है, जो किसी ना किसी स्टैब्लिश्ड या रजिस्टर्ड ट्रेडमार्क की कॉपी हो. मूविंग अहेड, व्हाट इज अ मार्क देन? सो मार्क इंक्लूड्स, ये सारी चीजें कहीं ना कहीं मार्क, ट्रेडमार्क में जो मार्क वर्ड है उसमें इंक्लूडेड है, विच इंक्लूड्स ए डिवाइस, ब्रांड, हेडिंग, लेबल, टिकट, नेम, signature, word, letter, numeral, shape of goods, packaging or combination of colors or any combination thereof. So what is a trademark? A mark which is capable of being represented graphically and is capable of distinguishing the goods and the services of one person from the other person. और ये distinguish या differences हम कैसे देख सकते हैं? With the shape of a product, with the packaging or with the colors. The color combination जो एक product में use किया जाता है, उससे कहीं ना कहीं आप difference create कर सकते हैं कि एक product और दूसरे product से अलग कैसे है. So these are some of the examples. For example, Unilever. I kindly request you to mute your mic. Then there is our favorite, everybody's favorite, MACD ka M, the way they write M, and there is a punch line there. I'm loving it. And then next, it is the Tata. ऐसे बहुत सारे examples आपको और भी दिए जा सकते हैं. For example, Mercedes और Audi के जो circles हैं. So there are many examples that actually can be given. These are some of the examples just to give you an idea कि ऐसे trademarks ऐसे use किए जाते हैं. So what are the essential features कहीं ना कहीं एक trademark protection लेने के लिए? Firstly, it must be distinctive. Next, it must not be deceptive. Deceptive means, again, deceptively similar किसी और product से नहीं होना चाहिए है, जो कहीं ना कहीं buyer के दिमाग में confusion पैदा करे. First, distinctive, which means unique in itself or different from others. For example, Apple for computers. Then no worldwide protection mechanism through one application, as ये जो trademark है वो कहीं ना कहीं एक territorial right है. Now what are the basic principles? जब एक registration के लिए जाते हैं तो कौन कौन सी चीजें हैं जो दिमाग में रखी जाती हैं, या what are the criterias for registering a trademark? Firstly, deceptive words जो हैं, surnames जो हैं, geographical names जो हैं, उनको कहीं ना कहीं register नहीं किया जा सकता. Then registration must not interfere with the bona fide use of a person of his own name or his place of business, or use of any bona fide description of the character or quality of the goods. Then prior user जो है trademarks के, वो कहीं ना कहीं must be protected against any monopoly rights granted under the statute, under the act. Then public interest, misleading नहीं होना चाहिए. Public policy, public interest के खिलाफ नहीं होना चाहिए. Misleading नहीं होना चाहिए. Then again, interest of other traders, right? अगर बाकी traders जो है उनका interest भी उसमें है, या फिर अगर register नहीं भी हुआ है, तो there is a remedy which can be claimed, जो आगे slide में मैं आपको remedies में बताऊंगी. Conditional registration in respect of honest and concurrent use. Removal of mark from register on the ground of non-use. तो ये भी एक clause है कि if it has not been used from many years, then it can be removed from the register. Then assignment or transmission to be as person condition of registration. Any person of public entitled to object to registration of ट्रेडमार्क. सो कोई भी पब्लिक में अगर कोई ऐसा है जिसको ऑब्जेक्शन है इस पर्टिकुलर ट्रेडमार्क को रजिस्टर करने से, या फिर वो खुद ये ट्रेडमार्क यूज कर रहा है जो उसको लगता है कि डिसेप्टिवली सिमिलर है, देन ही कैन अप्रोच द अथॉरिटीज. He can approach the authorities and ask them, or can actually ask them for the clarification, or can actually object to the registration of that particular trademark. Now, what is the procedure of registration? First of all, an application has to be sent by the person who wants to get protection against that particular trademark. Then it is accepted or rejected by the registrar. Now, if it is rejected, absolutely there has to be grounds, and they have to state the grounds as well when the application has been rejected. So there are two types of grounds for refusal: absolute grounds and relative grounds. Next is advertisement of application must be there after it is accepted. Opposition to registration within 3 months of advertisement. Then hearing of parties can be entertained if at all there is any objection. Then in that case, the trademark can be registered if the process has been completed, if the procedure has been completed. Moving ahead, what do you mean by absolute ground and relative ground? So absolute grounds for the refusal are stated under Section 9 of Trademark Act. And these are the conditions, or these are the following things which needs to be considered, or which comes under the absolute grounds. So first is the marks which are devoid of any distinct character. मतलब repetition है और कोई नई चीज नहीं है या फिर similar है, तो कहीं ना कहीं it becomes an absolute ground for refusal. Consisting of exclusively of marks or indications which may serve in trade to designate the kind, quality, purpose, values, geographical origin, or time of production of goods, rendering of services, or any other character feature of goods or service. Next, which consists exclusively of marks or indication which have become customary in certain language or in the bona fide sense or established practice of that particular trade. Next, if it deceives or creates a kind of confusion, or it deceives the public, then in that case कहीं ना कहीं ऐसा mark register नहीं हो सकता और वो absolute ground का part बन सकता है. Next, if it consists of such matter likely to hurt the religious feelings or religious sentiments of a particular community or a particular group, it can be rejected. Next, if it contains some scandalous or obscene matter, it can be rejected on absolute grounds. Then, if it is prohibited under the Emblem and Names Act 1950, also all the emblems and names are somehow protected. So if the name or the trademark name or the logo or the punchline comes under the prohibition under this act, it can be refused. And lastly, consisting exclusively of shape of goods. So these are the grounds on which the application can be rejected. So what are the relative grounds? Relative grounds are specified under Section 11. So a trademark can be registered if there is some identification issues, as in it is identical with some earlier trademark, या फिर वो similar है, it is similar to the product or the services of the earlier trademark, its similarity to an earlier trademark. Then next, identity or similarity of the goods and services, that I have already discussed it. So कहीं ना कहीं अगर confusion पैदा करने वाली, again वही बात आ गई, if there is likelihood, there are certain slight chance also that it will create a confusion in the minds of the buyer, then it can be a relative ground for refusal. So well-known marks are given protection and they are not refused registration. Why? The reason is because they well-known means they are established marks. Right, this exactly is the reason. And there is one case law as well, wherein in Jeep Flashlight Industries Limited versus Registrar of Trademarks, it was held by the court that even if the appellant's proposed trademark satisfies the condition under this particular Trademark Act, the appellant is not entitled as a matter of right to be register his or her trademark. It is open to the registrar to decline the registration or to register the appellant's trademark. So somehow कहीं ना कहीं ये registrar के ऊपर भी एक decision making है कि if he thinks that it will create a confusion or there is a trademark which has been earlier registered, so he can actually refuse it for the registration. And the term of registration is usually 10 years. Now there is classification of goods and services. Registration of trademark or a service mark is allowed in respect of one class of goods or services only, in accordance with the international classification or international standards, which are laid down in the convention or in the international conventions. So as far as this act is concerned, in the 4th schedule, this classification is stated. So there are various classes. So class 1 to 34 is for goods, and from class 35 to 42 is dedicated to services. So what do you mean by infringement, and what is infringement of trademarks? Infringement is nothing but violation of this IP right. So wherein what are the circumstances wherein infringement takes place? So if a person uses another person's registered trademark, it can be a ground for infringement. Similarly, if a person other than the registered proprietor in the course of trade in relation to that particular good or service for which the mark is registered uses the same mark or service mark, then it can be considered as deceptively similar mark. So what are the essentials of infringement, or what are the necessary things which needs to be proved in the court of law to prove infringement of trademarks? So that is taking off any essential feature of that particular mark or taking the whole of it. So अगर partial चीजें भी एक particular mark का copy किया गया है, then also it can constitute to infringement. Then again, if few other additions are made or alterations are made, but जो original mark है वो वैसे ही है, बस उसमें थोड़े alterations कर दिए गए हैं, additions कर दिए गए हैं, and उस state में भी कहीं ना कहीं it will amount to or it will constitute infringement or violation of intellectual property. The infringing mark must be used in the course of trade, that is in a regular trade wherein proprietor of the mark is engaged. So जिसका कॉपी किया जा रहा है वो ही सेम प्रोडक्ट है या वो ही सेम सर्विस मार्क है, उसी पर्टिकुलर प्रोडक्ट या सर्विस को बिलोंग करता है, तो ही कहीं ना कहीं इन्फ्रिंजमेंट होगा. अदरवाइज अगर कोई गुड्स है और उस पे मार्क लिया जा रहा है बट सर्विस मार्क लिया जा रहा है, तो देन इट कैन बी अलाउड इफ अगर वो पूरा कॉपी नहीं है तो. नेक्स्ट, the use of this particular mark which has been infringed must be printed or usual representation of the mark. तो कहीं ना कहीं graphical representation जरूरी है, कहीं print हुआ हो या कहीं publish हुआ हो. So publication here becomes an important factor. For example, advertisement or in bills, invoices, या फिर आजकल online सारी चीजें चल गई हैं, तो online अगर कहीं available है, then in that case it needs to be published. और ये hard copy जैसे हम कहते हैं कि सिर्फ एक oral use of trademark cannot amount to infringement. It must be in the actual form or graphical form which is visible to our eyes. Next, any or all of the above acts will constitute to infringement. Moving ahead, there are two things, infringement and passing off. So what is the basic difference between passing off and infringement? Infringement is nothing but unauthorized use, which is a violation of intellectual property under this particular Trademark Act. What is passing off? Passing off is basically common law remedy, or not remedy, but it is a common law tort which can be used to enforce unregistered rights, right? So passing off can be considered as tort. Tort means a civil wrong. In law, we call a tort as a civil wrong, which protects the goodwill of a trader from misrepresentation, from any kind of default, or from any kind of fraud, basically, that is caused, या फिर किसी goodwill या reputation उस particular brand या उस particular services और goods की कहीं ना कहीं hamper अगर हो रही है, तो वो कहीं ना कहीं passing off या goodwill को attack है, या reputation अगर किसी brand की stake पर है, then in that case, in those particular case, passing off can be of help. So what are the remedies? There are two types of remedies, criminal remedies and civil remedies. So criminal remedies, basically there is imprisonment or fine. Civil remedies, it is injunction, damages or account of profits. वो जितना भी damage हुआ है फिर उतना compensation दिया जाएगा, that comes under damages. For the non-law faculty or non-law students who are non-law scholars who are present over here, let me tell you what injunction is. Injunction is an order which is passed by the court of law, wherein court restricts or restrains one party from doing a particular thing. So common language में जो बोला जाता है कि stay लगा दिया उस particular work पे. So that is to restrain the activities of a party. So that order is known as injunction. Moving ahead, shall I continue with patents? If there is any doubt in trademarks, we can entertain the questions. Do you have any doubts in trademarks? Then I'll move further with patents.
Anyone, if you have any doubt, you can unmute yourself and ask your question.
Shall we move further, ma'am, with patents?
Yes, ma'am.
Yeah. Okay. So what is a patent? Patent is another type of intellectual property rights. Exclusive right एक particular product पे या process of manufacturing a particular good. So the law which is available over here is the Patents Act 1970. And in 2005, it was last amended. What is a patent now? So a patent is a set of exclusive rights which is granted by state to a person जो कहीं ना कहीं नई चीज लेकर आ रहा है, who is an inventor or his assignee for a fixed period of time in exchange for the disclosure of that particular invention. So the term patent and invention is defined under this particular act in section 2. So section 2 defines patent as a patent for any invention which is granted under this particular act. Then what is an invention? Invention means any new product or process which involves inventive step and it is capable of industrial application. So there are two terms यहाँ पे जो बहुत important है. Firstly, inventive step, कोई एक नई चीज होनी चाहिए है. Mere discovery of what already exists in nature cannot be called as invention. It has to be an inventive step, inventive process जो कहीं ना कहीं इजाद की गई है by the person. Next, capable of industrial application means commercially कहीं ना कहीं इसका commercial use होना चाहिए इस particular product का और process का. So there are both the product and process can be patented. And the person who gets his product or process patented is called as patentee. So these are certain inventions which cannot be patented. It is covered under the under section 3 and 4 of Patents Act. So an invention which is frivolous or it is contrary to natural laws, public order, public morality cannot be patented. Again, mere discovery of scientific principles cannot be patented. And now if I want कि law of gravity के लिए patent लिया जाए कि the whole process, so that cannot be done. Why? Because it is a scientific principle, Newton's law, it is established rule, it is established doctrine which has been established and which is known to everybody. So mere discovery will not amount to an invention. Mere discovery of a new form of known substance with absence of significant efficacy or new use or new property of known substance or mere use of known process kahin na kahin category mein nahi aayega, and this particular kind of invention cannot be patented. Next, mere admixture means simply अगर आपने 2 या 3 प्रोडक्ट को मिक्स करके एक नया प्रोडक्ट you claimed it as a new product just by mixing 2 or more products, then in that case mere mixture cannot be stated as an inventive step. Mere arrangement and rearrangement of known devices cannot be called as a patent, cannot be claimed to be patented. Moving ahead, method of horticulture, agriculture, treatments cannot be patented. Plants and animals and biological process for its production cannot be patented. Mathematical, business and computer programs per se cannot be patented. Next, literary, dramatic, musical and artistic work cannot be patented. Why they cannot be patented is unko intellectual property kahin na kahin copyright ke under protect karti hai, to isliye they cannot be patented. Literary work, dramatic work, musical work, artistic work jitne bhi hain unke liye we have Copyright Act aur unpe copyright milta hai, isliye it cannot be patented. Mere scheme, rule, performing mental act, etc. cannot be patented. Presentation of information, topography of integrated circuits or traditional knowledge cannot be patented, and the inventions which are relating to atomic energy cannot be patented. So now moving ahead with how to obtain a patent. So to obtain a patent, the whole process is divided into few steps which has been enumerated in the chart. So first process is application needs to be submitted in the patent office. Then provisional specification is filed. After provisional specification, complete specification needs to be filed within 12 months by the person who wants patent on a particular product or process. Then advertisement of acceptance of specification needs to be done. Publication of application is important. Then request of examination of application is done. Report of examiners come, and the examiners also have to mention the grounds of refusal. If they are refusing a particular product or process, then they also have to mention the grounds for that. So approval, objections, or division of application. Amendment of objections after hearing the parties, hearing both the parties jinko objection hai and the patentee. And last, if the process is complete or process clear agar ho jati hai, then in that case patent is sealed or patent is granted to the person, and now he can be called as patentee. There are certain diagrams on which patents can be entertained. Yeah, patents mile hain. These are certain diagrams, integrated circuits, jinko kahin na kahin patent mila hai. Moving ahead, what are the rights of a patentee? Patentee के पास क्या क्या rights होते हैं, and how can he protect or exclude other persons from using this particular patent? So the owner of patent, that is the patentee, is entitled to deal with certain rights. Firstly, patentee can sell whole or part of the property. Here property means patent. He can also license the patented property to another person, and he can also assign such property to another person. And the term is 20 years from the date of filing the application. So now, very interesting part of patent law, that is disputes under patent law. You all have we all eat basmati rice, and it is our famous. But do you know the legal complication that was faced by Indian government Let's see. So here Basmati हमारे यहाँ इंडिया में it has been used, it has been manufactured, it has been used from time immemorial. I mean, I cannot actually calculate the number of years we have been eating it. And we all know the history of basmati rice as well, कि वो एक टिपिकल क्लाइमेट उसके लिए चाहिए होता है, एक टिपिकल एटमॉस्फेयर चाहिए होता है ताकि ये राइस ग्रो कर सके. और इसकी जो महत्वता है या इम्पोर्टेंस है, सिग्निफिकेंस है बासमती राइस का ओवर अदर टाइप्स ऑफ राइस, आई कैन नॉट एक्चुअली एक्सप्लेन इट. यू ऑल माइट बी अवेयर ऑफ इट. It is everybody's favorite. So now there was a case in 1997, actually American company थी. Let me simplify it and explain it to you. American company थी जिसने US patent office में कहीं ना कहीं बासमती के लिए claim किया. That is outside India. So here उसने international market में कहीं ना कहीं establish होने की कोशिश करी, so that they can create, they can make basmati and they can actually sell it in the market. और उसको जो उन्होंने नाम दिया, that was Kasmati or Texmati was the name, जो बासमती type के rice को उन्होंने नाम दिया. And it went for the it was filed की patent लेने के लिए. So here somehow क्योंकि Indian government, it was an eye opener for the Indian government, and then Indian government actually approached the US patent office when they came to know that such a basmati, such type of basmati rice will be registered और उसको patent मिल जाएगा जिसका Kasmati या Texmati नाम रहेगा. So the Indian government approached US patent office and they re-examined and they actually requested or urged for the re-examination of this particular patent. क्योंकि इंडिया में from time immemorial बासमती उगाया जा रहा है और यूज किया जा रहा है, खाया जा रहा है, कंज्यूम किया जा रहा है, और ये कहीं ना कहीं बाहर भी भेजा जाता है. So export भी होता है बासमती राइस. So moving ahead, हुआ क्या? So there were political challenges, there were judicial challenges as well, but ultimately कहीं ना कहीं out of 20 claims, 15 कहीं ना कहीं ये जो US company थी उनको withdraw करने पड़े because of objection which was made by the Indian government. एंड कहीं ना कहीं ये मुद्दा बहुत उठ के आया, इसलिए इस पर्टिकुलर चीज के बाद कहीं ना कहीं जीआई या फिर जियोग्राफिकल इंडिकेशन का जो इम्पोर्टेंस है हमें समझ में आया, और उसके बाद जियोग्राफिकल इंडिकेशन एक्ट वाज एनफोर्स्ड इन इंडिया. नेक्स्ट केस इज टर्मरिक केस. Turmeric, we all know, is haldi. So 95 में there was this defendants Suman K. Das and Harihar P. Kohli were granted US patent on using turmeric for wound healing. So India woke up late again again, and then they but they won the case against the attempt by 2 US based Indians to patent turmeric. Same thing happened with Neem patent case as well, and again India won the Neem case at European Patent Office. So this was all about patents. Moving ahead with the copyright, ma'am, can we discuss all the questions afterwards?
Yes, ma'am. That is totally up to you. Yes, ma'am.
Yeah. So let's see what copyright is and what has Copyright Act to say about copyright protection. So copyright is protected under Copyright Act 1957, and the latest amendment was made in 2012. And the recent development in the copyright area or IP area of copyright was Copyright Amendment Rules, which were enforced in 2021. Let me tell you, these are amendment rules, and act is different and rules are different. Okay, so what is this copyright law? This particular copyright law was enforced with the main objective of encouraging the authors, composers, artists, designers who create original works. So to reward them with the exclusive right, this particular copyright concept was somehow evolved. so that they can get an exclusive right over that particular work, original work that they have created by spending their time, by spending their intellect, and by spending their money for a limited period to exploit the work for monetary gain, for the profit, to earn profit basically. So to earn profit as well as to give certain kind of protection to them, इसलिए इसको भी रजिस्टर करना जरूरी होता है, so that protection can be claimed बाद में if there is infringement of copyright. So it protects the writers or the creator of the original work from unauthorized reproduction or exploitation of the material जो already copyrighted है. So author, who is the author, and author of what kind of work, this needs to be understood. So it is defined under the Act. Literary or dramatic work, right? Musical work, for the musical work, music composer is the person who will be given copyright. For artistic work, it is the artist who has made it. For the photograph, it is the person who has taken the photograph. Cinematographic film, for cinematographic film, and for the sound recording, it is the producer who is entitled to get the copyright. So आप ये जितने भी remixes देखते हैं of the songs, जितने भी पुराने गाने हैं उनके remixes अभी बनाए जा रहे हैं, तो what exactly is the process? अगर remix बनाना है तो what is the process? तो प्रोड्यूसर को अप्रोच किया जाता है और पहले म्यूजिक कंपोजर को अप्रोच किया जाता है, उनसे वो राइट्स बाय किए जाते हैं और उनको रॉयल्टी दी जाती है, और based on the mutual understanding, whatever the case is, or in whatever the cases, if any. So इस circumstances में पहले कहीं ना कहीं आपको परमिशन लेनी होती है, और you have to buy the copyright rights of that particular song, फिर उसको remix आप कर पाते हो. This is the basic process जिसमें royalty भी involved होती है. Monetary sense में अगर बोला जाए तो it has been bought, rights are bought. Next, work, what kinds of work is included? So literary work, for example, all the books, novels, magazines which are registered can come under literary work. Dramatic work, musical work, so all the notes of lyrics and script writing, वो कहीं ना कहीं यहाँ पे आती है. Artistic work, the paintings, the sculptures, the sketching is covered under artistic work. Cinematographic film or the sound recording. Examples, these are the notes जो कहीं ना कहीं देखे जाते हैं. So these are certain literary works. J.K. Rowling's famous Harry Potter की जो नॉवल है जो काफी फेमस है, या चेतन भगत की नॉवल हुई. सो somehow these are copyrighted. Okay, so what is copyright and what is this exactly is, what are the acts which come under the copyright? Subject matter of copyright is covered under section 14 of Copyrights Act. So a copyright gives what kind of rights or authorizes what kind of acts to the person who has bought it. So firstly, to reproduce the work in any material form, to publish the work, to perform the work in public, to promote it, to advertise it, to produce, reproduce, perform, or publish any translation of that work, to make any cinematographic film or a record in respect to that work, to communicate the work by broadcasting it, or to communicate it to the public by loudspeaker or any other similar instrument. In short, promotion, or to promote your work. Next, to make any adaptation of work. So जो भी books हैं जिनकी movies बनती है, which is based on some of the novel or some of the books, तो वो कहीं ना कहीं leads to adaptation. To do in relation to a translation or an adaptation of the work, any of these acts which are specified under this. So these are all subject matters of copyright which are covered under this particular act. So registration is not compulsory for the protection. Infringement. Now, what do you mean by infringement? So in general, it is the commercial exploitation of the work in any form by a person who is not authorized to do it. Will actually, such particular act will amount to infringement or violation of that intellectual property rights. And there are certain exceptions also. So these exceptions are covered under section 52, which are known as fair use of that particular work. So what are these? Reproduction of use in judicial proceedings and for the use of members of the legislature. For example, reference के लिए अगर कहीं पे use किया गया है that particular work, then it can be categorized as a fair use कहीं ना कहीं. Next, publication of short passages, restricted reproduction or performance for educational purposes. जो भी हम पढ़ाते हैं या जो भी हम पढ़ते हैं, नोट्स बनाते हैं हमारे, वो बुक से लिए जाते हैं, डिफरेंट काइंड्स ऑफ बुक्स, यूट्यूब और अलग अलग जगहों से हम नोट्स कलेक्ट करके बनाते हैं, या फिर जब एक थीसिस बनाई जाती है, पीएचडी थीसिस, और एक एलएलएम या कहीं पीजी डिसर्टेशन बनाई जाती है, तो what we do is we refer n number of sources, primary and secondary sources of information or data, which we collect the data first and then we collect it, analyze it, and then we use it in our research work. So ये जो भी educational purpose का काम होता है, that comes under fair use. Next, making of records under license from copyright board on payment of royalty, जैसा कि मैंने आपको अभी एक एग्जांपल दिया था. प्ले रिमिक्स सॉन्ग्स जो है जिनका रिमिक्स आजकल बहुत आ रहा है, वो एक बहुत अच्छा एग्जांपल है ये थर्ड पॉइंट का. नेक्स्ट, प्लेइंग ऑफ रिकॉर्ड्स और परफॉर्मेंस बाय अ क्लब और सोसाइटी फॉर द बेनिफिट बेनिफिट ऑफ द मेंबर्स ऑफ रिलीजियस इंस्टीट्यूशंस. सो जो भी म्यूजिकल वर्क है, इट कैन बी रिकॉर्ड्स आप उनके चला सकते हो, यू कैन प्ले सॉन्ग्स. तो ये जो भी एंटरटेनमेंट पर्पस के लिए किया जाता है, या फिर रिलीजियस इंस्टीट्यूशंस में अगर रिलीजियस बेस्ड सॉन्ग्स चल रहे हैं तो कहीं ना कहीं ये फेयर यूज में आएगा. नेक्स्ट, reproduction of an article on current economic, political, social or religious matters in newspaper and magazines, etc. कहीं ना कहीं fair use में आता है. For example, social media और mass media, newspaper, news channels में जो भी चीज दिखाई जाती है, कहीं ना कहीं वो information impart करने के purpose से दिखाई जाती है. So this is considered as fair use. Reproduction of few copies for use in libraries or research work or private use के लिए जो हम books खरीदते हैं कहीं ना कहीं, so वो fair use का part है. Novels, we buy novels, cassettes, CDs, etc. Matters published in official gazettes including Act of Parliaments or its translation, जैसे Indian Constitution, भारतीय संविधान के books अलग अलग publishers उसको कहीं ना कहीं ट्रांसलेट, आजकल ट्रांसलेशन भी होने लगा है. सो हिंदी और इंग्लिश में तो वैसे ओरिजिनली ही अवेलेबल है, बट आजकल उसको बाकी लैंग्वेजेस में भी ट्रांसलेट करके उसको पब्लिश किया जा रहा है. तो इट इज अ फेयर यूज. व्हाई? बिकॉज इट इज फॉर द रिसर्च पर्पस एंड एजुकेशनल पर्पस. नेक्स्ट, मेकिंग ऑफ ए ड्राइंग, इंग्रेविंग और फोटोग्राफी ऑफ आर्किटेक्चरल वर्क ऑफ आर्ट or scriptures kept in a public place cannot be considered as copyright. Next, use of artistic work in a cinematography film. So that films are made or web series or these serials are made for the recreational purpose and for the purpose of entertainment. So somehow if some artistic work has been shown in a particular film or in a particular web series or serials, then kahin na kahin usko copyright ka part nahi mana jayega. Use of an artistic work by the author of any mold, right? Mold, sketch, plan, model made by him, तो कहीं ना कहीं अगर वो खुद वो उसको डिस्प्ले कर रहा है, author not the owner of copyright is important over here. तो वो इन्फ्रिंजमेंट कहलाएगा. अदरवाइज अगर वो खुद यूज कर रहा है तो वो फेयर यूज ही कहलाएगा, डिस्प्ले और एनी काइंड ऑफ अदर वर्क. Then making of an object in 3 dimension of an artistic work in 2D, subjected to certain conditions. So it is a part of fair use, which will not be considered as infringement of copyright. The lastly, but not the least, reconstruction of a building in accordance with architectural drawing somehow is a fair use and cannot be considered as infringement. So what is the term? So term is the lifetime of author plus 60 years beginning from the next year after the death of the owner. So this is the term for copyright ki copyright kitne time tak ye jo rights hain wo us particular owner ke paas rahenge. Thank you. If there are questions, then if you want clarification on any of the slide or any of the part of the slide, I can show it to you again and we can discuss it.
Any questions, participants? Participants?
Yeah, good evening,
Yes.
ma'am.
Yes, good evening.
Yeah, what about national emblem and logos?
Okay. In respect to trademarks,
Yes, ma'am.
so it is prohibited. I'll show you this slide. I'll go back to it so we can discuss it in detail. Yes, so it can be an absolute ground. अगर किसी goods या किसी services के लिए, किसी भी goods या services के लिए अगर ऐसा है कि कोई भी emblem या names जो कहीं ना कहीं इस act में prohibit किए गए, prevent किए गए हैं, for example अशोक चक्र हुआ, वो कहीं पे भी use कहीं पे भी आप यूज नहीं कर सकते. Why? Because वो कहीं ना कहीं हमारी national sanctity को दर्शाता है. So there are certain names and there are certain emblems means जैसे अशोक चक्र है तो वो कहीं ना कहीं emblem, national emblem का part है. तो ये act है, ये एक specific act है. If you are not from, if you do not have a law background, let me tell you, this is an act by the name Emblems and Names Prevention of Improper Use Act 1950, जो कहीं ना कहीं कुछ names और emblems, signs को कहीं ना कहीं प्रोहिबिट करता है कि ये हर जगह यूज नहीं किए जा सकते. सो अगर ऐसा कोई प्रोडक्ट है जिसका ट्रेडमार्क उससे सिमिलर हो या एम्ब्लेम अशोक चक्र ही हो, ऐसा कुछ हो, तो कहीं ना कहीं वो हर जगह यूज नहीं किया जा सकता. इट इज प्रोहिबिटेड. सो ये कहीं ना कहीं एब्सोल्यूट ग्राउंड माना जाएगा फॉर द रिफ्यूजल ऑफ एप्लीकेशन ऑफ ट्रेडमार्क. आई होप आई हैव
Is this the same case as for the national flag, ma'am? When people just go outside on private tours, they have the national flag put. They claim they are representing the government of India when they are not. Actually, it's misleading.
We are talking about registration.
Yeah.
We are talking about registration of trademarks, right? So when a trademark will be registered, अगर मुझे मैं एक कोई business करती हूँ, for example, I am running a business, और मुझे अपने goods जो मैं manufacture कर रही हूँ, अगर मुझे उस goods का trademark बनाना है और मैं ऐसा कोई sign ले लूँ, for example, जो तिरंगा का पूरा flag है, national flag मैं कहीं paste करूँ और फिर मैं चाहूँ कि मैं उसका एक ट्रेडमार्क बना लूं, तो दैट वोंट बी एंटरटेन्ड. सो वी आर नॉट टॉकिंग अबाउट यूज ओवर हियर, वी आर टॉकिंग अबाउट रजिस्ट्रेशन ऑफ ट्रेडमार्क. ट्रेडमार्क एज इन कमर्शियल यूज के लिए हम जो मार्क्स यूज करते हैं, फॉर एग्जांपल मैकडी का जो एम है, दैट एम इज रजिस्टर्ड कि हाँ ये मैकडोनल्ड्स को कहीं ना कहीं एक आइडेंटिटी है. या फिर फॉर एग्जांपल आप रिलायंस देख लीजिए, दे हैव ए सर्टेन लोगो, राइट? फॉर एग्जाम्पल टाटा, मैंने एक वो आपको भी बताया था. सो द टी, जैसे वो टी यूज करते हैं, द कलर कॉम्बिनेशन, कैपिटल टी, स्मॉल टी, ये सारी चीजें कहीं ना कहीं ट्रेडमार्क कवर करता है. इट इज नॉट अबाउट यूज ऑफ ए पर्टिकुलर मार्क, इट इज अबाउट रजिस्ट्रेशन ऑफ ट्रेडमार्क. जो हम कहीं ना कहीं किसी प्रोडक्ट पे जब हम रजिस्टर करने जाते हैं, ट्रेडमार्क रजिस्टर करने जाते हैं, तो क्या क्या चीजें हैं जो रिफ्यूजल से हमें बचा सकती हैं, ये वो चीजें हैं विच विल बी हेल्पफुल. Moving ahead, any other doubts? If anyone wants any clarification on any of the point, I can go back and explain it to you again.
Anyone
Yes.
Anyone from the participant wants to ask any question, you can unmute yourself and ask the question, or you can even write your question in the chat box.
Yes. See,
evening,
apart
ma'am.
yes, good evening.
This is Crescenta from Holy Cross College. In our college, we have the incubation center, and students have come up with their startups. And these students at undergraduate level, they come up with the product. There is a mentor, a faculty who's a mentor. When registering for patenting, should the student's name be first or the faculty's name? Because these students sometimes leave the portals of the campus. So how are we to go ahead? Because once they leave, this has to be developed, and it is mostly the mentor who does the other work. So who should be the first inventor, and if we are going for patenting and things like that?
Okay, yes, ma'am, it is a very interesting question and a nice question. With this, I would like to clarify to you that it depends upon the institution, and it depends upon the rules that institution has set up or the department has set up for you. अगर आप पढ़ते पढ़ते कोई चीज स्टार्ट कर रहे हैं तो usually the patent goes in the name of university or the institution. Right? Why? Because you are using the lab, you are using all kinds of facilities are being provided by the university. So, जो भी आप create करते हैं product, or you are coming up with a product or process during that time period wherein faculty is using all the material from the lab, or जो भी resources हैं वो यूनिवर्सिटी आपको अवेलेबल करा रही है, इंस्टीट्यूशन आपको अवेलेबल करा रही है, तो इन दैट केस जो मुझे नॉलेज है, या फिर आई बेसिकली टीच इन एलएनसीटी यूनिवर्सिटी वेयरइन वी आल्सो हैव फार्मेसी एंड मेडिकल ओवर देयर. सो जो यहाँ का क्लॉज है, जो रूल है, दैट इज कि आप यूनिवर्सिटी के नाम से या इंस्टीट्यूशन के नाम से आप रजिस्टर करते हैं पेटेंट. वैसे it depends आपका क्या mutual understanding है, it depends upon that. Apart from this, if you have मतलब एक कोई भी particular व्यक्ति किसी भी product या process अपने नाम से भी ले सकता है, but then किसी और का involvement उसमें नहीं होना चाहिए. That is important, because अगर आप use पूरा university के resources आप use कर रहे हो, being a faculty or being the research scholar or XYZ, I don't mean to offend anyone right over here, but अगर आप personally जाओगे तो obvious सी बात है, जब university को पता चलेगा तो university will tell you to justify or clarify this particular thing. So जो आपकी university के norms हैं, those are very important over here. अगर आप अपने पर्सनल लैब में कोई चीज क्रिएट कर रहे हो और उस पे जाके पेटेंट ले रहे हो तो किसी को ऑब्जेक्शन नहीं होगा. But if you are using some resources from the institution, then it has to be the institution first. This is what our institution does. Whatever patent you have created, whatever patent is being created over here in the Department of Pharmacy, the patent goes to the institution along with, or जिसका भी नाम आता है फिर तो, the concerned person who has created it.
So to summarize, you mean to say that first the college, next the mentor, and then the students, ma'am, if though the inventor is a student?
See, it depends upon, that's what I am trying to tell you. It depends what resources you have taken from whom, right?
Okay.
If you have taken resources from the university, from the institution, then obviously the institution will tell you कि आप हमारा सब use कर रहे हैं, then you have to आपको हमारा नाम तो add करना ही होगा. So department or the institution is primarily important.
Okay, ma'am. Because the
So
institution does the major
yeah.
funding.
Yes,
So
yes,
the
exactly,
institution has
exactly.
given for the development of the
Funding
prototype
as well
and
as
everything.
yes,
The
funding as well
idea
as
is from the
resources.
student.
As well as resources, the
Yes.
laboratory, and all the services facility that institute provides you. So it has to be the institute first.
First. Okay, ma'am.
Yeah.
Thank you, ma'am.
Ma'am,
Thank
could I just have a clarification on this further ahead, if you don't mind?
Yeah, sure. What is your question?
Ma'am, another way would be, ma'am, when students come to this lab for the first time, there
Yes.
is a meeting where you tell them that the institution is going to be providing this from you. And there's like an MOU signed between every student and the university that whatever they are creating will be a property of the institution.
Yes,
beforehand.
definitely. So
Yeah. So then legally also
depends
the
upon
rights of
the
the institution
norms.
are protected.
Yeah, it depends upon the norms of the institution, what norms they have for the intellectual property.
Yes. So that MOU probably can be signed by anyone who's getting into this patenting activity. Everyone, any student, he's getting into this activity knowing that anything he creates is utilizing the resources of the institution or the laboratory and their funds. So therefore, the patent will be in the name of the university. वो पहले से लिखवा लो, contract करवा लो.
Yes, exactly.
Thank you.
Any other question? Yeah. Apart from intellectual property rights, मतलब मैंने सिर्फ 3 types ही कहीं ना कहीं cover किए हैं, and more types will be covered in the further lecture. Apart from copyright, trademark, and patent, there are other types of intellectual property rights as well. For example, geographical indication. For example, Kolhapuri chappals, which actually indicates एक particular region या geographically कोई place को या कोई area, geographical area को represent करता है, तो then in that case geographical indication act है 1999 में जो पास हुआ था. So there is geographical indication. Apart from that, there is trade secret and undisclosed matters. So trade secret, एक company के अगर trade secrets अगर कोई हैं, तो that is protected under intellectual property rights. Apart from that, layout circuits is protected under intellectual property rights. So this is the whole subject matter, how intellectual property rights goes.
There is one question in the chat box. I would like to read it out to you.
Yeah, I'll refer it.
It's, could you please differentiate passing off and infringement of trademark?
Yes, I'll show you the slide and I will clarify it to you. See, with this slide, you will understand it better. That's why. Okay. Yes. So infringement and passing off, अगर एक simple layman language में मैं आपको समझाऊं, वो ये है कि infringement is on the violation of laws या violation of a provision जो कहीं ना कहीं act के द्वारा protected है. जो भी trademark registered है, वो कहीं ना कहीं infringement का part बनेगा. अगर कोई unregistered प्रोडक्ट है तो वो पासिंग ऑफ का एक्शन उसके ऊपर ये सिविल रॉन्ग की कैटेगरी में आ सकता है. ये एक बेसिक डिफरेंस है बिटवीन इन्फ्रिंजमेंट एंड पासिंग ऑफ. जब हम पासिंग ऑफ की बात करते हैं तो इट इज बेस्ड ऑन द कॉमन लॉ कॉन्सेप्ट. फॉर द नॉन लॉ स्टूडेंट्स, लेट मी टेल यू व्हाट टॉट इज. टॉट मींस इज एनी काइंड ऑफ सिविल रॉन्ग. ऐसा रॉन्ग जिसपे कहीं ना कहीं जो पनिशमेंट है वो फाइन या वो कहीं ना कहीं इम्प्रिजनमेंट नहीं है. इट इज ए सिविल रॉन्ग जिसमें कॉम्पनसेशन ही दिया जाता है. तो यहाँ पे जितने भी अनरजिस्टर्ड राइट्स हैं उनको इन्फोर्स करने के लिए पासिंग ऑफ इज इम्पोर्टेंट. एज फार एज इन्फ्रिंजमेंट इज कंसर्न, सो अगर कोई ट्रेडमार्क एक्ट के तहत रजिस्टर्ड है तो ही वो इंफ्रिंजमेंट कहलाएगा, अदरवाइज अगर अनऑथराइज यूज है तो ही वो वायलेशन कहलाएगा, विच विल अमाउंट टू इंफ्रिंजमेंट. इफ इट इज टू इन्फोर्स अनरजिस्टर्ड राइट्स तो वो पासिंग ऑफ की कैटेगरी में आएगा. और ये क्यों जरूरी है? जस्ट टू प्रोटेक्ट द गुडविल, जो कहीं ना कहीं एक ब्रांड, एक पर्सन या एक कंपनी जो इतनी मेहनत करती है और जो एक गुडविल और रेपुटेशन अटैच होती है एक ब्रांड से, सो उसको कहीं ना कहीं वो गुडविल प्रोटेक्ट करने के लिए दिस पासिंग ऑफ रेमेडीज इज देयर. आई होप you're clear with the distinction. Any other clarification?
Any other questions from the participants?
Ma'am, I guess this topic will be covered tomorrow as well. It will be continued
Yes,
by
ma'am.
some other speaker. Yes.
Yes, ma'am.
Yeah.
Yes, ma'am. I think there are no more questions from the participants.
Okay.
Yes, ma'am. So thank you so much, ma'am. It was a wonderful session. And thank you for sparing your precious time for us and for the participants.
Thank you. Thank you. Thank you. Thank you so much.
Thank you.
So I can see the chat box. Thank you so much.
Yes, ma'am.
If you want some other clarification or any information regarding it, you can also contact me. There's my email address given over here. Ma'am, do you want me to leave?
Yes, ma'am. If you are like over with it, you
If
can.
there are no questions, if there is any question or they want any discussion, I can go further with it.
No, ma'am. I don't think there are any further questions because everybody is in the chat box. They are thanking you and they are praising you.
Thank you so much. Thank you. Okay, so I will leave then.
Okay, thank you so much, ma'am. Thank you.
Thank you. Thank you.